Could I welcome our witnesses to the committee, and if I could just ask you please to, with a big, clear, loud voice on the record, to say who you are and who you represent, and if you would like to make a brief introductory statement, you're very welcome to do so. And since we went left to right last time, we'll start right to left this time with Mr. Hines.
I'm Steve Hines, I'm the Director of Legal Action Group. We're primarily concerned about access to justice and the general public. A few opening remarks. Government is saying that legal aid's expanded beyond its original remit. We take issue with this. In fact, much of what the government is saying we take issue with. Give one example, 1984 was the largest expansion in recent years of legal aid under Margaret Thatcher's government, and that was the PACE Act. Nobody's talking about repealing that. International comparisons, there's been a lot of figures bandied about that are actually inaccurate. I could quote at length from Europe and New Zealand, if needs be. Rising cost. You look at the figures, the last government actually was quite successful in controlling the costs. We did take issue with them, the way that they went about that. But you look at the costs of legal aid, particularly on the civil side, which is bearing the brunt of these cuts, something like 280 million. It's been under control for about 4 years at least. And of course the previous Conservative government was successful in cutting back on scope that was used as a blunt instrument, let's say, for controlling costs at that time. I could go on, but no doubt members will want to follow up on some questions.
Hello, Rachel Robinson, I'm a Policy Officer at Liberty. By way of a very brief introductory statement, we have very grave concerns about parts 1 and 2 of the bill, the impact on access to justice for very vulnerable people, and also their potential to create a real culture of impunity, not just in public authorities but also big business, whereby victims can't challenge wrongdoing, which obviously has wider social implications. Insofar as Part 3 of the bill is concerned, we take a very different approach. I think it's largely a sensible set of proposals.
My name is Roger Smith. I'm the Director of Justice. I suppose I'll make 3 preliminary points. One, as you'd expect, we are very unhappy with the cuts to eligibility and scope in the paper. That's in the bill. That's our particular concern. We'll be very familiar with the arguments in relation to that. 2, I think the bill itself is a bit of a dog's dinner, to be honest. There are 24 pages of exclusions, and I wonder whether that's going to be stable to establish so complex a situation. And thirdly, we're very concerned with the end of the Legal Services Commission and what we see as insufficient guarantees of independence of decision making.
Thank you very much indeed. Now, could I remind members, this is a shorter session than the previous one. This session finishes at 3 o'clock, so we've got 40 minutes. And we're going to open the bowling with those who missed out on their opportunity last time. So we'll start off with Mr. Tom Brake.
Thank you. Could I come to a part of the bill that we haven't discussed at all before, and that's the review of indeterminate prison sentences. And I was wondering what your view of that was, or at least what you were hoping was going to come out of the review.
In terms of indeterminate sentences, whilst we don't have provision in the bill, we certainly welcome a commitment to review these sentences. We've had real concerns about the use of indeterminate sentences for a very long time. They are bad for rehabilitation in that prisoners are facing a huge amount of uncertainty. They're unable to prepare for life in the outside world without knowing when their release date is going to be. We hear from our advice and information service, which takes queries from the public, that individuals are sort of chasing courses, not able to get on the courses they want to at a particular establishment, and therefore thwarted in their efforts to attain a certain release date. We think these measures are sort of very bad in cost terms. They've imposed a huge cost burden, and they're very bad for rehabilitation.
We agree with that. They're wrong in principle, and they set up a catch-22 situation where you can get out if you could do a course, but you can't do a course, so you can't get out. So we welcome the review. We will welcome their demise.
Right, and just to be clear then, you believe that there is no, that there should not be any indeterminate sentences?
I think it's in the sense that I think you mean the question, yes. I mean, there's an issue about life in prison, what that meant. But I think that in the sense of you commit a crime, I mean, you commit a crime, you do the time. That's where I think we begin. Once you start meddling with that, there are real difficulties.
Liberty?
I would agree with that assessment.
Thank you.
Dave Watts.
Can we go to the number of it? The government's claim is that the present system is unaffordable and expensive in comparison to other countries around the world. We've heard the examples of New Zealand, but it does seem to me a very strange example to use because I don't see much in common between the UK and New Zealand. But you said earlier that you had some comparisons information you could give us. What do you feel is the most appropriate comparison, and how do we compare with perhaps some of the other countries that you've looked at?
Well, I look behind me because Lord Back is sitting there, and I don't want him to stab me in the back because he commissioned a very good round-robin piece of research called Bowles and Perry from York University in his time as Legal Aid Minister. I wouldn't read the conclusions of that report or executive summary too closely. It seems to me to be slightly filleted, but you look at the report in its entirety and it gives a fair picture. In a nutshell, in continental Europe, inquisitorial systems cost a lot less in legal aid. But of course you take the costs of the whole court systems and they come out analogously similar to the UK. It's got to be said, though, in the UK, we have big policy differences regarding criminal law, and that means that we prosecute more people, we imprison more people. That means more costs in the system. That's a decision, obviously, of this Parliament to do that. And so that means that we have more costs compared to many jurisdictions. New Zealand's really interesting. Things are changing in New Zealand. I'd look, if members are interested, at Section 114 of their regulations on legal aid, or legal services they call it. You look at that and pretty much in civil, the means test, you convert the New Zealand dollar, much the same level of means test as we have, slightly over average income for an average family of 30,000 or so a year, and they would be entitled to civil legal aid in New Zealand. There's a different spread of services, there's different types of law, so you can't draw direct comparisons, but New Zealand overall spends about £20 per head. We spend about 38 on legal aid. It's a different legal system. The other point that I'd make in the common law world, it's very difficult to make comparisons because you have the state systems in the common law world. So, for example, Queensland in Australia is completely different to any other state in Australia. Ontario in Canada, somewhere I know Roger knows very well, they have a legal aid system. Indeed, they have a legal aid board very similar to us. They spend less on crime, certainly. You look at that per head of population. You look at their civil system. I'd argue it's a much better system because they deliver it through a salaried service. But the parallels that have been drawn, I think, have been slightly misleading, to say the least.
Could I come in with
Roger
the obvious comparator, I think, is Scotland. 10, 15 years ago, the Scottish legal aid scheme was the same as ours, and it's diverged. Some funny things have happened. They've retained legal aid for personal injury. They've just increased eligibility to it, 30,000 from 10,000. And how have they been able to do that? Well, it's been a much better managed scheme, to be honest. They've avoided all the nonsense of CFAs. What they've done is sort of little adjustments on the tiller instead of going for grand. And I mean, in some ways, this bill is in the tradition of two previous governments' approaches to legal aid, grand gestures. We've got to do something big and enormous to get legal aid under control. And we've had all this sort of franchising, competitive tendering, all these great things that were going to come. And the Scots have just made little amendments here and there, one or two salaried lawyers here, a bit of duty counsel there, and they've managed the system much better. It's a real criticism of how we've done it over 2 decades.
Just to interject there, though, they don't have the very high cost cases costs that we do. And that 400 or so cases costs around 200 million a year. Of course, they come down here to our Supreme Court for that. But broadly, what Roger is saying is correct. And it's got to be said, the scheme has been better managed. because it's been less politicised. There's been less tinkering with the scheme and introducing of general different management systems, and it's led to more stability and a more stable market in terms of the supply base.
If I can just briefly say, I agree with a lot of what Steve said in terms of the huge amount of the huge number of variables and the difficulty of making comparisons. But in addition to that, Liberty believes that this is a question about what kind of society we want to be as well. Successive post-war governments recognised that access to free legal advice for those who can't afford to pay is as important as access to free healthcare, to education. And we don't see the same sort of race to the bottom in these areas. We don't see an attempt to justify ever-increasing cuts against the spend of other countries, heedless of the social consequences.
Right, this is a tighter session than the previous session, so we're going to have to make it tighter. So Liz Truss, then Helen Goodman.
Thank you. I mean, in answer to the question, what kind of society do we want to be? I don't think we want to be a litigious society, and my fear is that the high legal aid bill is actually fueling legal involvement in things where it shouldn't be, such as lots of the content of employment tribunals or the welfare system, where these issues could be easily sorted out using a proper appeals process. I just wanted to come in on the point about international comparisons. The figure you quoted for New Zealand, which sounds more up to date, is almost double that of the UK. I think it's not sorry, the other way around. I don't think it's right to compare the inquisitorial system. My question is on Canada. What are the income thresholds there, and what is the scope of cases that are eligible for legal aid in Canada? Because it seems to me, when I've taken a cursory glance at these other systems, there is generally a lower scope and lower income thresholds in those similar countries than there is here in Britain.
Well,
Steve Hines.
Returning a couple of points. First of all, we spend around $5 million on employment law. That's just for initial advice and some preparation. There's no representation in employment law. Never has been, though we've campaigned for it. So we think there'll be further costs if people don't get initial advice in employment law cases, because one of the advantages is you can tell somebody they've got a rubbish case, don't waste your time by bringing it to plugging up the tribunal system. On the Canadian point in Ontario, they have certainly a stricter means test on the criminal side.
Because what is the means test? Can you give us a number?
I can't give you chapter and verse on the means test. I've actually got it in the office in the file.
It would be really helpful if you would send that.
It definitely is a stricter means test for criminal. I've used one example, anecdotal. One of my colleagues over in Canada said, well, you get accused of a crime and you have property in Canada, you often have to get loans against your property. I just don't think this government would want to go down that path. And the New Zealand example is very interesting. If you look at Section 8 of their Legal Services Act, one of the criteria for legal aid is whether the person accused of a crime has had legal aid before. Well, again, I just don't think in English law and European law that would be permitted in this jurisdiction.
Roger Smith.
So it actually differs greatly between the different provinces. No doubt that eligibility levels are lower, payment levels are lower. I mean, Ontario has just finished a major strike where council refused to appear in guns and gangs cases, rather shrewdly keeping up their other business to keep the income flow, and actually brought the government to heel, interestingly. But so not a very Canada's not a very happy place. I think 20 years ago it was at the cutting edge of legal development, so Canada's not really there anymore.
And just very briefly, if we're talking about, to reiterate the point, if we're talking about countries like Canada and Australia, there's huge variation between different provinces. And just to emphasise again, the real difficulty, which has been acknowledged by drafters of sort of comparison research, the real difficulty we have in making these kind of strict comparisons when there are so many variables.
But it just seems to me it's on each variable, the scope is wider, the income threshold is higher, and the cost per head is higher in the UK. So I think whichever variable you look at, it does seem to be we're at the high end.
You look at Perry's research, it doesn't say that. It says, for example, in the Netherlands, they actually spend more on criminal. That's a good example in Europe. And look at the civil legal aid systems, and actually ours has been diminishing over recent years compared to other jurisdictions. There's no doubt the case that if you look at headline figures, particularly in continental Europe, we do spend more on legal aid, but that's because we have
But I
an
said similar
adversarial
legal
system.
systems. I didn't say
Well,
the inquisitorial
if
systems.
you want the figures, they're here. I mean, page 27 of Bowles and Perry's report, and it goes there in chapter and verse. It doesn't have Germany. Germany's a federal system. They spend slightly more. We spend 80 euros, Sweden 71 euros, Netherlands 90 euros, and France 51 euros. So Germany's actually about 90 euros per head of population as total. But the thing with Germany, it's a bit more like a common law jurisdiction because it has a federal system. So their costs are higher because they have an analogous to a federal system like Canada or the other common law world.
Rachel Robinson.
Right, Canada is by and large cheaper, but there are twists to it. Ontario has a province-wide network of what we would call law centres, which is more expensive relative to their system than we would have. So there are twists to it. But your basic point is right. I think Canadian services are cheaper, narrower, and frankly less acceptable in terms of the quality that they give.
Rachel Robinson.
And we're talking about variations not just within the legal aid system, but variations outside of that within the justice system, which impacts what you can read into statistics dealing with legal aid. So variations in the complexity of legislation, social circumstances more generally. It's not, you can't just simplistically say, there's a higher spend on legal aid, we're being wasteful. There's lots of other things to consider, and that's why the difficulty in making comparisons.
Helen Goodman, then Ben Wallace.
To ask Mr. Smith some questions about the sentencing part of the bill. You have been critical of the extension in the curfew requirements.
Yes.
And I wonder if you could explain to the committee why that is, since I think many people think that curfew requirements are a particularly efficient way of dealing with offenders.
I think our issue is about the length.
Yes, that's right.
I mean, it's not about the principle in a sense. We're not arguing you can't have curfews, but if you're having curfews in the region of 16 hours a day or whatever, we think that gets very close to being sort of house arrest, and therefore crosses a line.
What line does that cross?
It crosses the line between an acceptable restriction of liberty towards creating what is more effectively described as house arrest.
If I could
Rachel Robinson.
briefly add to that, whilst we recognise that extended curfews are less restrictive on liberty, for example, than a custodial sentence, Liberty has a residual concern, whilst we do welcome many of the sentencing proposals, that these kind of extended community penalties may not actually be used in practice as an alternative to custody. They may be used in circumstances where custody wouldn't be envisaged, and we have to make sure we have proper safeguards in that respect.
Helen Goodman.
I'm sorry, Mr. Smith, I don't really understand the point you're making. I mean, if you're making a linguistic point about you don't want something called house arrest, but you do want something called curfews, I think you're making a more fundamental point than that. Yeah. But I'm not a lawyer, and when I say I don't understand, I really mean I don't really understand what the point is you're making.
Well, what I'm saying is, one, we're not against the principle of curfew, so you can keep somebody in their house for a period of time. I think that has to be a proportionate, reasonable period of time. I think 16 hours is too long.
And is that because you think that for the kinds of offence that a person will have committed, it is disproportionate?
Roger Smith.
I mean, why do you not? If you think that, presumably, what follows from that is that you don't think anyone should ever go to prison. I mean, and I'm sure you don't think that.
No, I just think that our line, we feel that 16 hours is just too long. I think if it was shorter than that, that would be acceptable.
Right, thank you. You also, I want to ask you about what you've said about bail, where you think that the adult bail provisions have gone too far. I take it by that you mean that you think that there should be more reasons for remanding people to prison than the government have included in their proposals.
Yeah, on the bail proposals, I'll have to write to you on those, because it wasn't me that actually did the work in relation to that, but I can write to you with a coherent... I'll set out our arguments in relation to bail in writing to you.
I also want to ask you about conditional cautions, where you're very critical of the police being able to issue conditional cautions without reference to the CPS. Why does that worry you?
Well, we're concerned about sort of mission creep in relation to the police. I mean, the police's job, the essential job of the police should be the investigator that obtains the evidence which is then prosecuted. So we're concerned about a mission creep where they go beyond that to being effectively giving you a sentence. And we think that's an unfortunate extension of role, which is wrong in principle and potentially has practical problems if it starts to figure in the kind of negotiations that might occur between a police officer investigating a case and the suspect.
If I could just add to that, I'm sorry. We also have grave concerns about the use of out-of-court disposals and proposals to take prosecutors out of the equation do exacerbate those. However, also you mentioned bail a moment ago. I'd like to sort of acknowledge Liberty's support for proposals which will mean that those who are unlikely to face a custodial sentence are not sort of clogging up the prison systems in circumstances where it's really not sensible. It's a very common sense proposal as far as we're concerned.
Thank you.
Ben Wallace and then Elfyn Twig.
Go back slightly to what Mr. Smith said about obviously the Scottish system. I think it's right, and Steve Haynes is correct about the very high cost cases, and most of that through the SFO and down south is a big impact. But the contention seems to be that actually, and it did come across from both yourself and Mr. Haynes, that the Department of Justice should be looking more at perhaps taking some money out of the criminal legal aid. If there's money to be found, or money to find, we should be tougher on criminal legal aid than we should on civil. And the Scots did save some money in that way, and I've had meetings with academics from Scotland who have said that. But they've also found themselves in trouble, CADA and things like that, things like where withdrawal of legal advice from the police station has actually found them in hot water with the European Convention of Human Rights and the courts. That aside, you still think we should be looking at criminal legal aid and there's money to be taken from that?
I was making a general point that I think Scottish legal aid has been well managed in terms of the use of salaried lawyers here and there very strategically, and we had a big experiment with a public defender solicitors operation which was really set up to fail and did, and I think the Scots have been much more shrewd about making sort of small practical rather than non-political.
They make tremendous savings because the prosecutor chooses the venue of prosecution. I mean, that in itself would save a lot of money, but I don't think we'd get through Parliament here removing the right by trial in the way that Scots do. I mean,
to answer the question, you could look again at fees within the system. Again, Lord Back knows all about this. He reduced fees by 12.5% in criminal, and it was a stepped reduction, the last one coming through in the current year. You could look at very high cost cases again. I think most members of the committee will be aware of Sir Bill Callaghan's letter of the 7th of February, and he sets out from the Commission some savings that could be made from criminal. There's also hanging in the air, of course, competitive tendering. There's a split within the profession in competitive tendering. Quite a few of the larger firms believe that if they had the volumes of work from police station to Crown Court, High Court work, they would save money of the order of 10%. So you can probably take it as read it's going to be more than that. I would warn that one danger, of course, of that is the potential for cartels. And indeed, Roger Smith, when he was my predecessor, did some work in North America on that. So, yes, you could look at criminal again. You can't look at scope, obviously. And you've mentioned the case of CADA. But you can look at fees. But there's two warnings in that, which is you can make savings, but it means consolidation in the market, lack of choice, and potential for cartels. and then you have the potential to lose excellence within the system. Lawyers will tend, obviously, to oversell themselves in terms of their excellence and their worth, but if you push and push and push, you get to a stage, perhaps, where you lose, particularly at the top end, the advocacy and other skills that you need.
Alvin Freud and then Yvonne Favard.
The bill creates a new offence of threatening an individual with a knife or bladed instruments, which will carry 6 months prison sentence as a mandatory sentence. What, in your view, are the pros and cons of mandatory minimum sentences?
Liberty in general is very cautious of mandatory minimum sentences. However, in this particular example, there is a clause which allows for judicial discretion in the interest of justice to come into the equation. So we're not overly concerned because we think there is flexibility built into the system.
Difficult to see why the offence is necessary. Somebody carrying out the acts for this offence will be committing other offences anyway. So this is pandering to the public in the usual way. And as a principle, mandatory sentences are a nightmare because you will always find there's a bad case that comes up which makes them ridiculous.
Mr. Hines, have you a view at all?
I concur with what Roger Smith just said, yes.
We've heard before, by the way, that the law was adequate in this field before, and there may be something to do with the press, we don't know.
Well, I have to comment there, but really, would we be having this same debate if events that happened over the last couple of weeks happened a month ago? The Lord Chancellor was pilloried by sections of the Murdoch press, and we ended up with the bill we have now before us. I think much of what was originally planned was on the right lines, but I gather the other side there as well don't agree with that.
Thank you.
Yvonne Favard and then Kate Green.
Thank you, Mr. Chair. I don't know if it's Legal Action Group that actually coined the phrase advice desert, but you've certainly warned us about advice deserts in the past. What do you believe the advice landscape will look like if the proposals to remove social welfare law from scope go through?
Well, I wish Legal Action Group had coined it. It was James Sandbach, actually, at the Citizens Advice Bureau. I noticed he was sitting behind before. The landscape will be decimated. On the civil side, our estimate is that we probably will go down to something like between 500 and 900 firms undertaking legal aid in family. It will mean pretty much in every parliamentary constituency you will have problems if there's conflicts of interest. In terms of the not-for-profit sector, I think you've heard a lot of evidence of that already. The government have got their impact assessment up to date, and it's around 60 million that would be lost in what we call social welfare law, the specialist end of citizens' advice, 18 law centres, quite a few of the independents, and we've produced a lot of data on this. In fact, in this month's Legal Action magazine, we've got an article outlining the effects on child poverty zones where there's a high incidence of child poverty, on the top 4 being in London. There will be it's difficult to exaggerate how bad the effect will be. But of course, to be devil's advocate, the government know that. It's in their impact assessment. The Lord Chancellor criticised Lady Hale for quoting from the impact assessment. The government, as a matter of policy, are saying that we know this will affect poor and marginalised communities, but we're going ahead with it because we have to save money. I mean, to be fair to them, they have been upfront about it.
Thank you. The access will be through a telephone gateway in the future. Do you have any comments about the appropriateness of this for the range of clients?
Oh dear. Yes, well, you had some answers already about this. Telephone gateways can work, I think, and it can complement a system of providers on the ground. But we did an opinion poll in November last year to coincide with the consultation, and this was an NOP piece of research, and it found that the people less likely to use internet and telephone services were groups DE in social groups, and they're the ones that qualify for legal aid. So there you've got your answer. Yeah, if you want a legal aid system that people don't use, then deliver it through telephone advice, because the ones that pass the means test tend to be the ones that don't have telephones. Big issue with this. is, of course, mobile phones and pay-as-you-go. Obviously, DE social group tend to have that type of mobile phone contract.
Thank you.
Kate Green.
I'd like to ask Roger Smith to expand on something he said in his introductory comments about his concerns about the insufficient guarantees of independence within the bill. And I assume what you're talking about there is the plan to take the functions of the Legal Services Commission back in-house, as it were. Assuming for the moment that the government is going to proceed with that proposal, can you suggest any safeguards that we ought to be seeing in the bill?
There should be an independent appeal process, as there is in this is an idea that we've pinched from New Zealand in legislation which has just gone through, and that has an independent appeal. They wound up their legal services agency, did it in the same way as this bill does, but they gave an independent appeal process, and that's the minimum you need. Because what you're going to get is you'll get people maybe politically motivated, wanting to judicially review the Lord Chancellor. They'll be refused legal aid. So they'll be taking judicial review against a refusal, give them legal aid for a judicial review, and it'll just spiral out of, in a way it's a gift, if you wanted to close off people who will bring cases against the department and make a fuss about it. It's the minimum you should do.
I think it's the report stage to do something about this. You've transposed the old Section 20 of the Access to Justice Act into Section 33, and I'd refer you again to Bill Callaghan's letter of the 7th. I don't think that gives sufficient protection. You need an internal ring-fence system where there's no chance of a Lord Chancellor or other ministers interfering, or more importantly, to be seen to be interfering with decisions on individual cases, because I think that's a political liability for any government, and you shouldn't be putting yourselves in that position. Roger's right, minimum should be an appeal system. You don't need an expensive tribunal system. You can adapt what you already have and have review panels and set something up. But that's a plea, I think, to look again what you have, because I actually don't think what you have in Section 33 achieves what you want it to.
Andy Slaughter, then Tom Brake.
Could I ask you about Clause 12 of the bill, which gives the sets the possibility for the director we were talking about to set merit and means tests in relation to police station advice, and what the view of particularly Liberty and Justice is on that?
Well, I think we've already had very good signals from both the Minister and the Secretary of State that they're going to look again at that. Again, I would say at report stage, I would hope that the government would bring something forward to repeal those provisions or to withdraw those provisions. I was very amused by the Secretary of State's performance at the second reading when he blamed the Labour opposition for it. Clearly it might be your fault, but he's in government, and I gather from the Minister that you're going to look again at that, which we're encouraged by. The case of CAD has already been mentioned. I think it's a given that we need to retain the police station advice that we have.
It's also a requirement. It's a requirement for the European Court, which was what the CADA case was about. We intervened in CADA, so we have some responsibility for this case, which requires the Scots to have a duty solicitor scheme they haven't had so far, and requires... the problem is if you don't see a solicitor and get advice before you're interviewed by the police, what you say in that interview may not be... it's not admissible in court. So I would hope that in the light of that, policy will remain as it is now, and hopefully the bill will be changed. But what's more important is what actually happens.
I can also voice Liberty's concerns in this respect. This clause, like many others in the bill, gives the Lord Chancellor powers in secondary legislation to do potentially very damaging things. Whilst we've had assurances that there's no immediate plans to introduce means and merits testing, this remains a possibility, and that's very concerning. It's concerning from a justice perspective, and it's also, and as others have said, but it's also incredibly concerning from a practical perspective, and in fact really unworkable, because what we're going to have is people sort of escorted into custody and then asked to, and then an attempt to make a means assessment without any of the available documentation which will make that possible.
in a previous session,
this
time if you were here for that, we asked about some of the specific scope areas. And I think I ought to give you the opportunity to say whether there are any areas of removal from scope which give you more concern than others. Clearly, we're going to be looking at many of the areas specifically as we go further through the committee stage, but it would be useful if you're here today to have an answer to that.
Well, thank you for the friendly question. I would say, particularly social welfare law, and really for practicalities here, I really can't understand the logic of the government deciding that repossession should be the criteria for a housing case. So you have the situation where you don't prevent litigation. People have to get to the stage of repossession before they get legal aid to defend them in court. It makes eminent sense to me, and I think to most thinkers in this field, that you get early advice. So you get housing advice, housing benefit advice, before you ever get into the situation where a property is repossessed. And looking down those areas are very common areas of law which affect ordinary people up and down the country. I just think it makes sense to retain them, because ultimately I think you can argue about the economics of it, but the state does save money and the private sector does save money. I would say also we were disappointed that the government didn't look at alternative methods of funding. We think that they're out there, it could be looked at. The government already has an alternative method of funding. It's called the legal aid impact test. It's not been changed in policy. Money is transferred within government when legislation is shown to have a legal aid impact. Family credit introduction led to, I think it was about 30 million being transferred from DWP. It would make sense to give that sort of market-based type inducement for government departments to get their decision-making right first time and save a lot of problems, mainly for the people at the sharp end of legal disputes.
If you took the view that the government is going to make these cuts broadly, and there's nothing any of us really can do about that except perhaps here and there, and I'm not disassociating myself from what Steve is saying on the broad picture, but if you were looking for a potential one winnable issue, I'd say it's clinical negligence. I think that is the most vulnerable issue for the government. You're going to get people with catastrophic injuries, birth defects. You're going to get major publicity coming down the line on this one. The cost is relatively small. The logic is incoherent. They were exempted from CFAs for a very good reason in the first place. And were you asking what could I concentrate on as the one winnable issue, my answer to that question would be clinical negligence.
If I could sketch out one overarching category of concern, the proposals in the bill are going to place many individuals who are challenging decisions of public authorities, whether that be a government department or public authorities more widely, that they're going to lose their ability practically to do that. And we're concerned that will have a real sort of impact of constitutional significance. It's going to some extent change the relationship between the individual and the state. And we already know that public authority problems with the standard of sort of the decision making in government departments like the Department for Work and Pensions and the UK Border Agency actually impose burdens of their own on the legal aid system. And as far as Liberty are concerned, these measures, rather than trying to deal with the underlying problem of a poor quality of administrative decision making, are just going to prevent people from challenging decisions, and that's really not the right way of going about it and cutting waste out of the system.
You've taken the next area I was going to ask about, and indeed talking about clinical negligence, you bring in part 2 as well as part 1 of the bill. It was put earlier, to an earlier witness, I think, by Elizabeth Truss, that wouldn't it be better to improve the quality of government decision making, then you wouldn't need to spend money on legal aid. I mean, you may not want to comment on that, but what do you mean by a greater constitutional significance here? I see what you mean in relation to being able to review the decisions of corporate bodies. And what do you see as the overall impact on access to justice of the bill as a whole?
There's an overarching sort of rule of law point here. The idea is that everybody is subject to the law, and that means not just the fact that there are laws in place which are in theory applicable to all. It means that people can vindicate their rights. People have practical access to justice. And when I talk about the constitutional argument, I talk about equal access to justice, and I talk about nobody being above the law and not having to sort of face the consequences of their administrative failures, for example. So that's the specific point I was seeking to address there. Overall, the impact of parts 1 and 2 of this bill on access to justice are going to be huge, and we are at Liberty are extremely concerned about proposals in relation to conditional fee agreements and after the event insurance. We think this is another example of situations in which victims are going to be unable to challenge very serious wrongdoing. In the case of conditional fee agreements, wrongdoing by very powerful multinational companies, such as in the Trafigura case, this isn't just going to have an impact on the individuals involved in a particular dispute. This is going to have an impact on the culture, how decisions are made in big business, and whether considerations like human rights and due process are taken into account by those who have a lot of power.
Can I just come in on that? The phrase access to justice just drives me mad. It's completely meaningless. Chipped onto the architrave of the United States Supreme Court is equal justice. And I take that to be, and that's a phrase I think the Americans read, and I take that to mean that in any dispute between two institutions or people, the result will be determined by the intrinsic inherent worth of the argument, and not by the relative money and resources that each have. And that's what's really important. And I think this bill threatens that in a variety of ways. And one thing we haven't got time to explore now is in relation to divorce. What will happen is poor people will be shoved into, and women will be shoved into mediation. And rich people, and men predominantly, will have the luxury of having lawyers. And you can use, you had an earlier discussion, I heard it, about mediation. Mediation, a really good thing. Mediation 1 is mediation for all. And you could exclude all lawyers from the divorce court. So, Prince Charles and Princess Di don't get one either. Everybody does mediation. But this bill is a mess because some category of people won't get lawyers, will be shoved into mediation, and others will get what they will see, probably rightly, as a better service.
Last question, Tom Brake.
Can I take you back to a different part of the bill, which is conditional cautions, which you've expressed great concern about. Can you set out any safeguards that you think could be put in place to address or partially address the concerns that you've got about those?
Consultation with the prosecutor.
Absolutely.
Right, well, doesn't that rather do away with the immediacy of a conditional caution?
It provides what I would say is the minimum acceptable check. It could be a phone call, but some measure of check from a person in another agency, in the prosecution agency.
Because as things stand, and as the situation will be if the bill it passes in its current form, a police officer will be acting effectively as investigator, as prosecutor, and as judge, and that's a matter for huge concern. We've seen a recent report by the HMIC which talks about inconsistency in different areas in the use of these protections, and we have concerns about maintaining open justice and ensuring that justice is both done and seen to be done by the wider community.
Thank you.
Well, that brings us to the end of our time for that session. Can I thank our witnesses very much indeed for giving up their time to give evidence to us today. Thank you very much indeed.